Please the court.
SJC-11939 in the matter of Philip Chism.
Pardon me. My name is...
Restrain your enthusiasm for one moment, Mr. Albano.
Try.
All right, now release your enthusiasm.
Thank you, Your Honor. My name is John Albano. I'm here on behalf of the appellants. Emma Hall is with me, and Zachary Kleinsasser is here on behalf of the Eagle Tribune. The Superior Court in this case held that suppression exhibits, once they are admitted in evidence, are presumptively public court records, and that the good cause test applies when a party seeks to impound those exhibits. Neither of those rulings was an error of law. The real dispute in the case, I suggest, is whether a Superior Court abuses its discretion by denying a motion to impound suppression exhibits before making a ruling on whether the motion to suppress will be allowed, but after determining that those exhibits will form the basis for the judicial ruling, and after determining that the court is able to protect the defendant's fair trial rights.
Just to be clear, you're by the time you ended the sentence, you're really talking about the application of that principle to this case. I mean, that's not a general proposition that you are making, the weighing there. In other words, it has to be on a case-by-case basis, or are you saying not?
No, it certainly does have to be on a case-by-case basis. The ruling of law that was correct is that that these are presumptively public court records, and that the good cause test applies.
Is that what distinguishes the two opinions? I thought the issue was, at least as presented by Mr. Levin, is whether or not the First Amendment right and the strict scrutiny analysis should apply, or whether or not the common law right of access with the impoundment standard should apply. Do you see it differently?
I would say this, the nature of the case raises both issues, but the Superior Court's decision, when it gets to applying the applicable test, is strictly applying the good cause test of the Uniform Rules on Impoundment Procedure and the cases of this court. So, for example, when it gets to that part, when the Superior Court got to that part of the analysis, it was not applying the strict scrutiny that this court in Pond said doesn't apply to certain judicial records. That is not the analysis he applied. The press enterprise to, is there a substantial probability of prejudice that to the defendant's fair trial rights that closure will effectively prevent, and that there are no less restrictive alternatives. The Superior Court applied the same test that's in the Uniform Rules of Impoundment Procedure, the good cause test. Now,
and you're not asking us to apply the First Amendment.
There's no need to apply the First Amendment test unless the common law test, unless the court held that the common law test did not provide a basis for the court's ruling. So, in other words, the court need not reach the First Amendment issue.
Mr. Albano,
Yes.
what's the Globe's interest in the videotape confession at this point, now that the case has been tried? I mean, what do you get out of this? Is it just the principle of the thing?
Well, I think not, Your Honor, because there still is a Superior Court decision that, in this case, for example, ruled that the defendant's statements were voluntary, in fact, ruled that the Commonwealth had proved by at least clear and convincing evidence that the defendant's statements were voluntary, that ruled that the police were put in, I think I'm quoting here, in an impossibly difficult position because of the tension between attempting to perhaps rescue a victim and adhering to the rules of interrogation, but that in the end, the Commonwealth had not proven to a moral certainty beyond a reasonable doubt that the statements were voluntary. I would say...
Miranda.
Yes, before or after that ruling.
I
There is a
understand.
public interest in the video, in
Okay.
seeing the video to judge the Superior Court's decision. That was really the heart, I would suggest, of the Superior Court's decision, that the Superior Court said, I am going to be relying on these exhibits, on this videotape, not just for the statements uttered, but for the demeanor of the people who were speaking, for their...
So whatever rule comes out of this case wouldn't be generally applicable, would it? I mean, it would just apply to this case because we do things on a case-by-case basis. So it wouldn't have any broad application that you could apply to some other interest that the Globe may have in some aspect of a court proceeding.
I think not, for two reasons, Your Honor. First of all, there are going to be other suppression hearings. There are going to be other motions to impound. And a ruling in this case will prevent the situation where, well, it's really the capable of repetition yet evading review principle, because there is now a single justice opinion that I would read as saying a Superior Court should, with great caution, if at all, deny a motion to impound exhibits that have not yet been ruled on in a suppression hearing, that calls into question whether the good cause standard applies, that calls into question whether these exhibits are presumptively public court records. So I would answer your question in two ways. There still exists a public interest in seeing the videotape, the evidence on which a judge relied in making such a significant judicial ruling, and there is an interest in clarifying whether the standard applied by the Superior Court is, in fact, the correct, as a matter of law, standard to be applied.
So play this out for me. I've been struggling with this. The judge could have said, I want to see the videotape in the courtroom. As opposed to taking it back to my lobby, I'm going to just have it played in open court. That happens sometimes. In that case, you'd have a First Amendment standard because you'd have to clear the courtroom in order to prevent people from hearing it. Should it matter as to whether or not the judge chooses to hear it in lobby versus chooses to hear it in the courtroom? Should that change the constitutional standard with regard to public access?
I do not believe, the answer is no to if we're applying the constitutional standard. If those exhibits are relied upon by a Superior Court in making a decision, then it should not matter if the court views them in open court or in chambers. If I may add, though, the fact that in a wise spirit of caution, the judge here, while the motion to impound was pending, did not play the videotape in open court. I have no complaint with that. But that actually increases the public interest in ultimately seeing, well, I would argue at that time, in seeing the videotape, because it is analogous to part of a proceeding being held in chambers where substantive evidence relied upon by a court is heard. And so while no one in this case has any complaint about the procedure followed by the Superior Court here, it would, I would suggest, make it all the more significant that, and a more significant public interest for that evidence viewed only in chambers to be made public.
Now,
Does it matter here that, I'm sorry, Chief?
No, go ahead.
Does it matter here that the timing of the hearing on the motion for impoundment, I mean, by the time the hearing was over, everything had been exposed as part of the motion to suppress hearings. So should that figure into the calculus about whether the impoundment order was appropriate?
Yes, Your Honor, and it supports the Superior Court's decision because, as this court has held, one of the factors that a court is entitled to consider in deciding whether to grant a motion to impound is this information going to be disclosed by other means? Has it already been disclosed? So yes, the fact that there was a public suppression hearing that disclosed at least some of the information that is at issue here cuts in favor of denying the motion to impound. So too do the public search warrant affidavits that
I'll
detail.
ask Mr. Levin about this, but I'm just puzzled about why it happened the way that it happened, that the motion to impound was not heard before or separate and apart from the motion to suppress. I mean, in a way that seems a little unfair to the defendant. I mean, that wouldn't be your issue, obviously, but
It seems, for what it's worth, from me, it seems like a wise decision by the Superior Court, because while that motion was under advisement, the exhibits were not disclosed to the public. They may as well have been sealed at that point. No one in the public saw them. And the Superior Court had 2 or 3 days of suppression hearings to familiarize himself with what was going to be disclosed in open court, reducing the need to impound certain materials, and to familiarize himself with the evidence and the testimony. So I would suggest no harm done by that. In fact, if anything, it was a more cautious way of deciding the motion to suppress. Certainly the fact that there had not been a ruling on admissibility is not an error of law on the Superior Court's part. There's never been that requirement imposed in the public court records decisions of this case. Search warrant affidavits can contain inadmissible information, bail materials, affidavits in support of restraining orders.
This is a videotape confession. Don't you think that that's a different species from a dry search warrant with facts recited in rote fashion by a police officer? I mean, here you have a 14-year-old confessing to murder, and that's not the same, is it?
Well, first of all, I completely agree that there is something different about videotapes when a judge is considering the defendant's fair trial rights. But if I may, I would add, there is also, it cuts on both sides, because if there is a suppression hearing that involves allegations of police misconduct recorded on a videotape, then to have the judge's decision be decided without the public seeing the basis for that decision is a significant issue. At the same time, on the side of the defendant's fair trial rights, the trial court is absolutely entitled to consider how will disclosure of this videotape affect the defendant's fair trial rights. Here, the Superior Court addressed that issue because he granted the defense motion to prohibit copying and duplication of the videotape.
So the Globe, for example, there's no way the Globe or any other media outlet could put portions of this on the internet, stream it, or anything like that?
There was never an opportunity to do that once the Superior Court granted the motion to prohibit duplication. And I would suggest that that issue, what do we do with videotaped confessions when there's a motion to suppress and a motion for public access, is a significant issue that should be addressed in the first instance by a Superior Court judge. It has not been addressed by the Superior Court in this case.
Now, you before said it's important that the videotape be played for the public, that the public see it, but then you also emphasized today, as you did in your brief, that we're not talking about duplication and copying, so even if you prevail, the public would not necessarily see it. But what would the public be able, what access are you specifically referring to?
Well, I interpret had the Superior Court's decision not been stayed, and had the court held to its decision to prohibit duplication, I interpret that decision to say, and copying, a member of the public, press or member of the public, could go into the courtroom and arrangements would be made for them to see the videotape.
So you would be able, the press or a member of the public would be able to see it, but not copy so that it could be put on TV.
That's the state of the record in this case.
So from the Globe's perspective, it could write, the reporters could write about what they saw, but they couldn't directly show the videotape.
Correct, yes.
And TV could report as to what it showed, but would not be able to show any part of the videotape, at least until the judge ruled as to the copying part.
That's correct. That's the state of the record in this case, and it's been that way since February, when of 2015, I guess.
And the impoundment would have a shelf life, so presumably after the trial, the Globe would be able to go back to the trial judge and ask him to lift the impoundment order or the copying order.
Certainly, if the Superior Court determined that impoundment was necessary to protect the defendant's fair trial rights, then I do agree that that equation would change after verdict and that there should be time limits on any impoundment order. I suspect the court would still have an issue in front, I'm running out of time, to see that because there's a possibility of retrials, appeals, and the like, so the argument would never fade, but the Superior Court still
It
should
would
have
fade
discretion.
after the rescript I mean, I guess it would diminish after the rescript were issued by this court if it were to affirm. We have abuse of discretion on two sides here. So am I correct that the issue is whether the single justice abused her discretion in concluding that the trial judge abused his discretion?
Yes, although I tend to phrase it a little differently, but I do think that's the essence of it. It seems to me that if the Superior Court did not abuse its discretion by making any errors of law, and we say the Superior Court did not, then the single justice's legal rulings that the Superior Court had committed errors of law should be vacated, and in essence, these trial courts' discretionary
Committed error
rulings
of
should be-
law, meaning didn't ever decide whether it's a public record, or do you mean committed error of law because an abuse of discretion ultimately is an error of law? Which do you mean?
Well, it seems to me the heart of the single justice's abuse of discretion argument was that the court applied the wrong standard and remanded to apply the correct standard. We
factors.
said he applied the correct standard. It is the good cause standard.
Can I just ask you one question about that? Sorry. So if the question whether the showing or the writing about or the, in any event, view in the courtroom of the videotape ultimately is a question of whether it impedes the defendant's fair trial rights, which is a constitutional question. So what is the relationship between that constitutional question and the common law good cause? I mean, how do those fit together?
Well, the common law right certainly takes into account the defendant's fair trial rights, and if there was no way to accommodate and protect the defendant's fair trial rights, then they clearly and absolutely and certainly trump the public's right of access. I do think, as was raised earlier, the public access issue can also be raised from a First Amendment standpoint. This is evidence, after all, on which a court is relying, and given this court's guidance that videotape interrogations and interviews should be more common than in the past, this is another reason why I believe the Superior Court should decide this first, because but for a recognition of the strong common law interests and, when appropriate, the First Amendment interests, we would have this unfortunate situation where the improvement of interviewing defendants results in a diminishment of the public's right to see and understand how resolutions of police misconduct intentional or unintentional, are resolved. And that's the constitutional interest underlying access to suppression hearings and the alternative way of analyzing the public records, the court records access issue.
All right, thank you.
Thank you.
Mr. Levin, good morning.
Good morning, Chief Justice Gantz. May it please the court, Patrick Levin on behalf of Philip Chism. I'd like to begin, if I may, with the standard that was applied by the Superior Court on this motion. I don't agree that he applied the good cause standard. I think it's clear from his order, which appears at page 163 of the record appendix, that he's applying a First Amendment strict scrutiny standard. At page 163, he says, after balancing the defendant's Sixth Amendment right to a fair trial with the public's First Amendment right to view the criminal proceedings, the defendant's motion must be denied. And he goes on and quotes First Amendment cases throughout the order. And at the end of his order, he says, the First Amendment poses a challenge for this court today in protecting the defendant's right to a fair trial. I think it's clear that he is applying a strict First Amendment scrutiny standard in his order. And so resolution of the matter in this court does require a judgment on this question of whether the First Amendment right applies.
And when the single justice sent it back and said you should apply the proper standard, what was the proper standard that was declared or established in her opinion?
Well, it seems to me from the single justice order that she held that the First Amendment strict scrutiny standard doesn't apply in this case, at least based on her citation to the 10th Circuit's decision in United States versus McVeigh.
Is that because of the distinction between the proceeding and the records? I mean, and the exhibits?
I don't recall the specific language in the single justice order. Certainly, that's the basis for the 10th Circuit decision that she quotes at length in a footnote in the single justice order, is this distinction between the public access to the suppression proceeding versus public access, physical access to the evidence that's sought to be suppressed at the hearing. And obviously my argument before this court is that the First Amendment does provide for public suppression hearings absent compelling interest that requires the hearing to be closed, but that the First Amendment does not require the evidence the defendant seeks to suppress at the hearing to be publicly accessible.
Well, the Globe cites the First Circuit opinion for that proposition. I can't remember the case now. Is it Republican versus?
Republican Company is a decision from this court.
Okay, well, the First Circuit opinion in the case that the question was reported in, they cite, the First Circuit seems to say that a First Amendment analysis would entitle the public to the records in a case. That's the case that Mr. Albano cites, that he relies on. If we were to assume that a First Amendment analysis applies in this case, if that case governs, then the judge was correct.
Right. I'm not 100% sure which particular case you're referring to,
Okay.
but I'm not aware of any case that's directly on point in terms of discussing public access to evidence that a defendant is seeking to suppress during a suppression hearing, with the exception of the McVeigh case.
Well, I think it was the Pokaski case where the Globe was trying to get access to closed records.
That's right.
And that's a little different from this case, but they do say in that case, and that's the case that the Globe relies on, that that the First Amendment entitles the public to these court records. So what's the
Yes.
difference?
That was the holding of the First Circuit Court of Appeals in Pulaski. That case, you're right, it dealt with the sealing statute for criminal records in closed cases. And the First Circuit did hold that the First Amendment applied to those records. That case was disagreed with a couple of years ago by this court in Commonwealth versus Pond.
Yeah, I know.
And
But,
so,
I mean, the First Circuit has the last word on the First Amendment, though, right?
well, no, the U.S. Supreme Court has the last
Well,
word
no,
on the
I
First
mean,
Amendment.
yes,
I
but
mean,
the,
obviously,
yeah, I
the-
understand
The
that.
First Circuit's guidance can be helpful, but absent controlling precedent from the U.S. Supreme Court, this court should make its own judgment on federal constitutional questions.
So going back to the question which you didn't answer the last time, if the first justice, I mean, if the single justice is correct and the judge is supposed to apply the proper standard, what is that standard?
Oh, I apologize, Your Honor. So the good cause, the impoundment standard, good cause to impound, would presumptively apply to these documents,
So we have this peculiar situation in which each of you now agree that that they are presumptively public records and the good cause standard should apply.
That's right, Your Honor, although in my brief, I argue that in
Or
fact.
actually, I'm sorry, he says actually we don't need to reach the issue where the First Amendment would apply. It's sufficient for the good cause standard to apply.
Right, well, so my position is if the good cause standard applies, you need to affirm the single justice order because that's not the standard that was applied in the Superior Court in this case.
And did it ever go back to I mean, I know it was remanded, but was that stayed because of the appeal here, or did the judge ever consider it on the new standard?
No, there never was a remand. This is a direct appeal from the single justice order.
What factors were not taken into account on the good cause standard at the trial level?
So the factors would be similar. The burden on the defendant would be less, essentially. And, but as I was saying, my argument in this court is that, in fact, the good cause standard should not apply specifically to video recordings of confessions.
I'm maybe confused. I thought you said that you agree they were presumptively public and the good cause standard applies.
That's right, but I'm urging this court to hold that with regard to this particular type of evidence in a suppression context, that at least until there's a ruling that the confession is admissible, that in fact they should not be deemed presumptively public.
Okay, but this just happened to be videotaped. If it were not, all that would have come out in open court.
That's right, Your Honor.
Would you say we should close the courtroom?
No.
So why does the fact that it is videotaped, putting aside, and Mr. Albano has been pretty clear that the issue of whether or not it may be copied is quite separate, but why can the public not see the videotape if the public would be entitled to have heard the police officer testify to the contents of the confession if it were not videotaped?
Because the impact of seeing a videotape of the defendant confessing to a crime is very different than the impact of hearing a police officer testify that the defendant confessed to a crime.
Well, I understand that, but the public would not see it. They would simply hear about it. The reporter for the Globe would see it. The reporter for Channel 7 would see it. But unless the court were to have permitted copying so that it could be seen, all they would be able to do was report about it.
Yes, I understand what you're asking now. The common law right is a right to inspect and copy. That's what the common law right to inspect judicial records is. That's how it's been referred to throughout the U.S. Supreme Court's cases and this court's cases. If a record is presumptively public, you're presumptively entitled to copy it.
But I think as the judge's order made clear, the presumption is a rebuttable one, at least both ways, but also with respect to copying. So the fact that they go together as a general statement of the principle doesn't mean they always have to go together.
So to be clear, what the judge allowed in this case was not the defendant's motion to prohibit copying. The judge allowed the defendant's motion to stay copying pending a further hearing. That's at page 190 of the record.
But we don't, I mean, at the moment, it hasn't been copied. So, I mean, I don't think we can say, well, we assume that he was going to allow that to
No.
copy.
You're right about that. There's no reason to assume one way or the other. But what I'm asking for is a rule of somewhat broader applicability.
Well, are you familiar with cases where the trial judge will have the video played in open court and the police officer will narrate, this is the time when he invoked, this is the time when I gave him a glass of water, et cetera?
I haven't personally seen a suppression hearing that's proceeded that way. I know that happens often at trial.
Okay, but, well, if that happened in a suppression hearing, what would be the difference if a news reporter from the Globe or from Channel 7 was in the courtroom and able to see the video being played like everyone else? They could certainly report on it, correct?
Absolutely, yes. I think it's true that the common law argument I'm making is directed more towards the copying and dissemination part of the common law right to copy.
Mr. Albano tells us we don't have to reach that issue, correct?
Yes, that's right. But I would urge this court to reach the issue. I think it's very important.
I'm sorry, reach the issue as to whether or not copying at any point in time? I mean, it seems like it's a different circumstance before trial than after trial.
Yes, specifically copying prior to a decision on suppression.
But you're also asking, I think, right, that the court to say that, forget about copying, it just shouldn't be, and nobody should see it before trial. Is that right?
Yeah, as a general matter, with videotaped confessions, we're asking for a rule that it's sort of a reversal of the presumption, that presumptively they should not be permitted to be copied and disseminated prior to trial.
Okay, how about seen by the press? How about inspected, I guess, the inspection theme? Could it be inspected by the press but not perhaps copied by the press?
The common law argument that we're making only goes towards the copying and dissemination.
So you would not be opposed to the press inspection of the videotape and reporting upon it, even if the reporting were to say the defendant confessed to all the crimes and describe the grisly details?
Well, back in this particular case, obviously, we were opposed to the press seeing it. We moved to impound the recording in toto.
Well, I'm confused. I thought you were asking for a rule that would say that you couldn't, the press also couldn't view it and then report on viewing it before trial. Is that not, you're not asking for that?
We're asking for a rule that, in general, the common law right of access to judicial records does not apply to videotaped confessions pre-trial.
So where does that take you?
So in this case, that would take us to an allowance of the motion to impound in the first instance.
Including which would deprive the press of the ability even to inspect.
Yes.
Okay.
But how is the press, how are we going to have any public accountability either for the police conduct or for the judge's, the wisdom of the judge's decision concerning suppression?
Well, the judge's decision...
Nobody knows what the content is of the statements.
Your Honor, I think the judge's decision in this case is perfectly intelligible without having seen the videotape. We can understand his reasons for the suppression of so much of the evidence as he suppressed based on his thorough memorandum. And I think that suffices for the public understanding of the suppression matter.
Well, I mean, we may be hearing the matter, so I won't discuss anything with regard to the content, but let us assume that it is a very thoughtful, very reasoned, very detailed opinion. It's not always that way. I'm sort of a little bit confused here because there is a distinction between inspection and copying, which you've but it does seem as if it's a big difference in terms of the ability of the public to understand what is going on in a trial if they cannot even inspect and report, especially where they could if there would have been no videotape. I mean, you're basically saying that the right of the public to understand what goes on with regard to a suppression hearing depends upon whether or not the police videotaped the statement, because if they did not, all this would play out in open court and the First Amendment would apply. But if it did, then they get nothing.
I think that,
They'd still get the open court.
well, yes, they're going to see the written motions, they're going to see the judge's written decision, they'll hear the arguments of counsel on both sides in open court, and they'll hear the testimony, and there will, I mean, it will be unusual for a hearing to go forward without testimony of any kind.
Well, there'll be testimony, but presumably if there's a videotape, there's not going to be testimony sort of reciting what the defendant said in the interrogation.
That's right.
So if a judge ruled on voluntariness grounds that the police were very hostile and bullied the defendant into a false confession and suppressed the confession, it's videotaped, the judge makes that finding on the record and writes an opinion, how's the public going to know whether or not the judge was correct?
Well, ultimately, after the trial, the question of public access would be probably revisited, and a number of courts have noted that access delayed is not the same as access denied. That the knowledge that your decision ultimately is subject to public review has a similar effect on the judge and on the prosecutor as the contemporaneous access does.
So after rescript?
After rescript, the balance of interest obviously changes.
Okay, thank you, sir.
Thank you very much.